Good evening, everyone, and welcome to Legal Hour. My name is Andrew Lynch, and I'm the Dean of the Faculty of Law and Justice at UNSW, and it's my great pleasure to be welcoming you to tonight's webinar for what promises to be a fascinating discussion on the topic of law versus big tech. I want to begin by acknowledging the traditional owners of the lands on which I'm speaking to you from tonight, the Bidjigal people. And I also acknowledge the traditional owners of the lands on which we are respectively gathered throughout the country. I pay my respects to elders past, present and emerging, and extend a particular welcome to any Aboriginal or Torres Strait Islander people in the audience. Legal Hour is the faculty's signature alumni event, and it's particularly significant this year. For 2021 is the faculty's golden anniversary. A minor housekeeping point just before we commence: tonight's discussion will be recorded and made public following the session. We thank all of you for logging in to join us tonight, but if you need to leave early or if you want to refer the discussion to others you know who would be interested and who are unable to make it, then we'll be emailing out a link to access the recording to everybody tomorrow. It's my pleasure now to introduce our moderator for this evening's discussion, Professor Lyria Bennett Moses, my colleague in the Faculty of Law and Justice, and also the Director of the Allens Hub for Technology, Law and Innovation. Thank you very much, Lyria.
Thank you very much, Andrew. I'm very excited to be here this evening with the panel. We have Valeska Bloch, Technology, Media, Telecommunications and Data Partner at Allens, Shoshana Shields, Director of Legal for Google Australia and New Zealand, and Dr. Katharine Kemp, my colleague at UNSW, a Senior Lecturer in the Faculty of Law and Justice and an expert in data privacy and competition law. This topic, law and big tech, is about as big tech. There are almost an infinite number of topics to explore, and I'm grateful to those members of the audience who've already sent in their questions, and I look forward to getting more during the session. I'll try to get to the meat of as many of those questions as I can. But one important thing to flag up front: while we are among friends, we are also among lawyers. I therefore hope that you all understand that there will be topics that our panelists are unable to discuss this evening. Where questions cut into that domain, either the panelist concerned or I on their behalf will simply pass on it, which does not signify any agreement or disagreement with what any other speakers may have already said. So I trust you all understand the need for that, but of course that still leaves us plenty to talk about, and so I'll just get started straight away. So the first question to the panel is, whenever law and technology are discussed together, there's always a question as to whether law is keeping up. I'm wondering what your thoughts are, both on the question as well as the answer. Valeska, would you like to start us off?
Sure. Thanks, Lyria, and hi, everyone. Look, I think it's a really good question. In many ways, law is constantly playing catch up to changes in technology and changes in different business models. And certainly, I think probably one of the areas where this has been most apparent in recent years is in the data space, and the law is certainly trying to catch up. So we have seen an incredible volume and pace of regulatory change in that space, particularly when it comes to data handling and also cybersecurity. And they're related, but not necessarily the same. I think in a recent discussion paper, it identified in Australia 51 different pieces of legislation that deal with cybersecurity sorts of regulation. And so that is an incredible amount of regulation for organisations to be keeping across. So, look, I think it is trying to catch up. I don't think it's necessarily getting ahead of the changes that we're seeing. And one of the difficulties or the challenges that I think organisations are facing is how to then keep up with this constant incremental change in the regulatory environment, because it's having to play catch up. And what we often find is that what ends up happening is that organisations, in order to comply, basically end up having to go through this box ticking exercise rather than necessarily taking a step back and figuring out what they need to do to meet the underlying objectives of the legislation in the first place. So I think that is one of the challenges that we're seeing. The other thing that we're seeing in this space, I think, is that there are clear areas where some of the legislation is outdated, but regulators are very aware of some of those pain points and are perhaps trying to shoehorn their regulatory enforcement activity, or rather shoehorn some of the outdated forms of legislation by using their enforcement activity to do that, even though the relevant behaviour in question may not be strictly contravening those existing regulatory frameworks. And I think that is something that we really need to keep a watch on, where there genuinely needs to be a change in law because of new technologies. As much as we'd like the regulatory environment to be technology neutral, that's not always going to be possible, and it's going to bite in different ways. But I think we do need to make sure that regulators are not approaching it in that way, and we're rather using the levers of regulatory reform to address those sorts of issues.
Thank you. Shoshana, I was going to go to you next as someone who's trying to manage all of this on behalf of an organisation. What are your thoughts?
Yeah, I think Valeska made some very good points. I guess I have a few things to say. Obviously, my view is that technology will always be ahead of the law because it has to be. I don't think you can preempt. Even technologists don't know what they're going to do next. They're so far ahead of the game that I think you kind of have to see what the technology is before you can identify what risks there are to the technology. And, you know, there are definitely areas that are always going to challenge the law. So, for example, even silly little things that none of us would even think about probably now, but, you know, e-signatures on contracts. It seems like no one would even think about that, but that's an area of law that's really had to have some thought about it. There was a time where you had to have the original. You couldn't rely on a PDF signature. And look at the way the world has worked in the last 12 months. How would we have functioned, you know, without being able to find a way to do things like that? And then there's even things now that are outdated, like, I wouldn't say outdated, but that create challenges for the law. The copyright law, you know, selling digital artwork on eBay technically could be a breach of copyright law, even though you want to show your viewers what they would be buying. So there are challenges everywhere where the law hasn't caught up. But I mean, if we look at data and things obviously closer to home for me, I mean, those examples were easy cop out for me. But if we look at data and things closer to home for me, I think things like the cloud, a great example of innovation and looking at how data is kept. And, you know, there was a time where the only data you could access was the data on your own computer. You couldn't go somewhere else and access your emails. You couldn't look at a document that you had written last week. You had to go to your own computer. And so the innovation behind that is obviously very useful, and people want to be able to have access to these things. And then comes the problem of, well, then how do you make sure you've got complete security around that data? Because previously, if it was only held on one computer, the security issue was a lot simpler proposition. So I think obviously that raises then, you know, how do you have better encryption technology, and what laws do you need? So I think there's always, the law is always going to follow the innovation and the technology, because you can't foresee those issues until later. But I would say one thing, and I think this was to Valeska's point about shoehorning regulation, that there's a risk to getting in too early with regulation, because a lot of these things develop and evolve. Even the technology companies are learning. They can't always foresee what could go wrong until it goes wrong, or what the issues are, and then they can come up with a very sophisticated solution, sometimes more sophisticated than a legal solution. So that's the only thing I would say, is that there is a risk, I think, in regulating too quickly, when things will self-moderate and consumer expectations and social norms automatically make the technology stricter about these legal and ethical norms.
Katharine, I was wondering about your thoughts, particularly given, in a way, the challenges that have been discussed so far actually will give academics things to talk about. So what are your thoughts coming from there?
Thanks, Lyria. This question actually, for me, it reminds me of a fairly notorious interview with Mark Zuckerberg back in 2010 when he was explaining to a live audience why Facebook believed that privacy protection was no longer a social norm and what Facebook was doing about that. And he was saying a lot of companies would be trapped by the conventions, and doing a privacy change for 350 million users is not the kind of thing a lot of companies would do. But we viewed that as a really important thing to always keep a beginner's mind. And what would we do if we were starting the company now and we decided that these would be the social norms now, and we just went for it? Of course, when you're starting a company, you don't usually get to decide these will be the social norms now and just go for it. That's a privilege that's reserved to companies that become such an integral, sometimes compulsory way, a part of the way we live, that they shape how things are done and what's acceptable. And I'd just say three quick things about this. First, policymakers obviously need to exercise judgment about whether innovation is actually a good thing in each case. It was Google's Larry Page who said, a law can't be right if it's 50 years old. And now Larry might want to revise that if he were given the chance. Maybe he'd concede that some laws are right even if they're centuries old. But we are often told the law mustn't stand in the way of innovation, as if innovation is by definition a good thing. Yet once upon a time, cocaine tonic was an innovation, thalidomide was an innovation, leaded petrol. I don't think we should get carried away with slogans about newness or being left behind. Second, I think law reform will be necessary to improve outcomes. I don't think recommendations alone will work, or self-regulation. We still have a situation where Google and Facebook collect data about us all over the web, even when we have no account with these companies. Woolworths Rewards and Flybuy still say they're tracking their members, even when members choose not to use their reward cards, 2 years after the ACCC said they should stop that. Incentives are such that these kind of practices won't change without changes in the law itself. And thirdly and finally, I think we shouldn't assume that business models are set in stone. It does take policymakers a while to catch up and realise what the consequences are of new technologies and business models. And so long sometimes that you'll have entire ecosystems built up around those business models, as in the case of digital advertising. But the fact that a horde of businesses are making money in a certain way shouldn't mean that we just assume that we just will regulate around the edges and accept the business model. Unelected companies shouldn't just get to decide these will be the social norms now. So yes, inevitably the law lags behind innovation in some respects. It tends to be late to the party, but it shouldn't be shy once it gets there.
Thank you, Katharine. Valeska, you talked before about a lot of the complexity that has to be managed in this area. What can legal practitioners do to support clients where things are grey, particularly where both law and technology are complex? Do you have any advice for lawyers and future lawyers, because we have some students in the audience interested in this domain?
Yeah, so look, I think the first thing is to not be shy about asking some very sort of simple fundamental questions about how the technology works, because that can actually make a real difference to how the law is going to apply to it. So that's kind of the first question. The other thing is that, I guess, going back to what I was saying before about there being this complexity, and that's even within the one jurisdiction, right? So in particular, certain sectors which are very highly regulated, they're dealing with multiple regimes, they're evolving quite quickly, and they're perhaps also having to deal with regimes overseas that are applying to them as well. how do you sort of navigate through that? And what we're increasingly finding is that it's becoming really important for organisations to have a governance framework that firstly identifies what the key regulatory themes are currently, what they are likely to change to, or how they are evolving on a global basis, and to try and define those, and then to take really a principle-based approach to how you deal with whatever the thing is that's being regulated. So again, to use data as an example, it's really helpful to be able to identify the fact that transparency and consumer control and security and ethics are actually all really fundamental themes around data handling, both overseas and in Australia. And it could be, for example, that at the moment our privacy regime doesn't necessarily pick up all of the issues that those themes raise, and it does touch on some of them, but we know it's going to change. We know there's going to be an overhaul of the Privacy Act. We know there's been the GDPR that's picking up on these issues. And we also know that consumers are expecting a whole range of things when it comes to their data nowadays that perhaps they hadn't been agitating for as much a number of years ago. So organisations are developing data governance frameworks to put some or to put that framework around how these practices are going to work within the organisations. And what we're also finding as part of those governance frameworks is that they're developing ethical principles. So whether that's ethical data handling principles or ethical AI principles. And what that does is that it means that it picks up that where you might get trapped, where there is a sudden change in law, so that you're not having to do a complete overhaul or about turn of your internal practices, because you've already been turning your mind to what's coming down the pipe, and also that behaviour that's a little bit more dodgy. And we might, this might come up a little bit later, but I guess we have seen over the past few years limitations to the Privacy Act, for example, where organisations might be complying with the bare minimum legal requirements. And then the ACCC is coming in to try and mop up what it's seeing as some of the consumer issues. And look, there's a question as to whether that's being done in the right way or not. But really, at its essence, what it's saying is that there are some slightly shonky practices there, and the law until now has not been picking those up. And so if you're applying the ethical lens to it and that broader data governance lens to it, that can help organisations navigate through some of the regulatory complexity.
Thanks, Valeska. Shoshana, if I can ask you the same question, but obviously from the perspective of someone advising a big tech company in-house.
Yeah, I think it's really important for legal practitioners to understand the technology and understand technology, and to understand topical issues, to understand policy considerations. I think it would be naive to say that they should just understand the law. I mean, we've just had this discussion about whether the law is outdated, and I think it is reaching a point where you have to start to bring in, okay, strictly the law says this, but these are the policy and social norms, and these are the expectations, and these are the ethical considerations, because I think it is starting to all wrap up together, and being informed of the whole situation is important. So my view is that, lawyers who are looking to work in this area, and, there are novel things, it's really complicated. There are areas where the laws don't match, the activities, and trying to work out how to apply that, I think, requires an understanding of the technology and the technical elements, as well as understanding the intent behind the law and the intent behind the social norms and ethical considerations.
Thanks. So moving on, I suppose, to something a little bit more specific, and Katharine, I might address this one to you to start with. Competition law often comes to mind when describing big anything, big tech included. over the last year in particular, we've seen some very bold legislative proposals coming out of the European Union and the United States, which aim to curb the economic power and practices of big tech. And also, in Australia, there are some proposals from the ACCC as well. What are the main proposals, and how likely are these to become law and have the desired effect?
Yeah, there can't be any doubt that in the past few years, we've seen this increasing spotlight on the tech giants in numerous jurisdictions and a desire to put some limits on the economic power enjoyed by those companies, to limit the negative effects on smaller firms and consumers, and some would say the effects on democracy itself. Earlier this year, the US House Judiciary Committee announced a package of antitrust bills that were aimed at reining in that power, and the majority report that preceded the bills compared today's tech giants to the oil barons and rail tycoons of a century ago. It claimed that the companies abused their powers by charging exorbitant fees, imposing oppressive terms, and extracting valuable data from people and businesses that rely on them. The European Union had already started down this road. The Commission there had published its proposal for the Digital Markets Act aimed at gatekeeper platforms, and the Bundeskartellamt in Germany has begun work under its new abuse of dominance law to add to its case against Facebook in the realm of data privacy terms. The UK government has released a paper on firms with strategic market status, and in Australia, well, most recently we've had yesterday's report by the ACCC in respect of digital advertising. That report found Google has a dominant position in key parts of the ad tech supply chain, and it alleged that Google has preferenced and shielded its own ad services in that supply chain. So the ACCC is saying it wants sector-specific rules to prevent conduct like self-preferencing and address the data advantages of major platforms. Last month as well, the ACCC Chair Rod Sims outlined a vision for strengthening our merger laws, including by putting special rules in place for acquisitions by large digital platforms. And there's word that we may soon have proposed legislation to enable our privacy regulator to develop a binding privacy code for digital platforms, including social media platforms. As to whether this is actually going to come to fruition, when we consider especially the bills that have been proposed in the US, they've really gone for the full buffet option in terms of what they're asking for. And the reality is that not all of the measures in those bills will ultimately be passed, but there will be significant changes, and we can see some common themes across these developments. One of them is that they focus in often on the famous five: Google, Apple, Facebook, Amazon, Microsoft. But in Australia, sometimes that focus is narrower, just on Google and Facebook, and sometimes Google alone, as we saw yesterday. There's also a focus on ex-ante regulation, and the idea there is that we are likely to get some more specific prescriptive rules that will apply to platforms from the outset, rather than pursuing litigation over a number of years to apply principles-based rules and prove contraventions. There'll be a focus on preventing self-preferencing and discrimination. And the ACCC is not alone in advocating for merger reform. Particularly, there's a focus on what is being called killer acquisitions of nascent rivals, where it's considered that digital platforms in particular have been able to identify potential competitive threats a long time in advance and buy up smaller companies to prevent a threat to their market power. So I think some of these kinds of measures will ultimately come to fruition, even if not all the current proposals. will ultimately come into being.
Thanks, Katharine. Shoshana, would you like to comment?
I feel like I have to. I would just say a few things. I think there is definitely a push towards regulation of large companies, and I say large or big rather than big tech, because it's not the tech that I think necessarily is coming under the ire, it's the bigness. And is this, you know, even Katharine used the word dominance. And I think there is this perception that if you're large and you're a tech company, then there's something wrong. And, you know, I would reiterate that there is no law against being big or large in Australia, but I do think there is this now perception that it is fraught. And as a result, as Katharine mentioned, there is a real push towards these now kind of looking at things in a different framework, not relying on our existing competition law framework. So, you know, Katharine mentioned the big oil companies and they were charging exorbitant fees or, you know, oppressive terms. They're all things that currently can be dealt with under the current framework. I think what's being looked at now is this kind of ex-ante laws and ex-ante rules that need to be made to monitor. And I would just say, I think it's premature at this stage, and obviously this is something that we understand is being looked at, and it's not just in Australia, but, you know, you have to look at whether what harms are actually being created and is there consumer harm, and whether making these rules actually could have unintended consequences of creating some other harm. And I think it's too early for us to look at that, but I do think these are interesting questions, and I do feel obviously being Google and being a large company has definitely invites us to be under the you know, spotlight for this.
Thank you. Okay, so I might move back to, I suppose this sort of links with some of the things you were saying earlier, Valeska, as well. So in the last couple of years, the ACCC has ventured into the territory of data privacy, making recommendations for strengthening privacy regulation in Australia and bringing cases under the consumer law in respect of the privacy practices of technology companies. Is this an appropriate role for a competition and consumer regulator? Or should privacy matters be addressed under, so in other words, should privacy matters be addressed under the consumer law when we have a Privacy Act and a privacy regulator?
Yeah, so it is a really good question. I mean, to be fair to the ACCC, some of the things that it says it's seeking to address, it is suggesting should be addressed as part of the reforms to the Privacy Act, which would then be dealt with by the OAIC. But then, of course, we're seeing as a result of recent enforcement activity that in the meantime, or until those gaps are closed, it is using the consumer law itself to try and deal with some of those issues. So, look, whether or not that's an appropriate approach is a tricky one. I think it is a confusing approach, particularly because it's a reasonably recent approach and because there's been some slightly mixed messages. So if you look at some of the recent activity, there's certainly a focus on transparency, for example, and making sure that the representations that organisations are making about its data handling practices are accurate, that they're not misleading or deceptive. And there's been a lot of commentary as well as part of the digital platforms inquiry about the importance of, on the one hand, being really transparent about data handling practices, which we know, particularly in the big tech space, are complex, and they are doing a lot of different things with data. And are innovating and also providing, you know, that there can be the darker side to it, but there are also some real benefits. But on the other hand, the ACCC is saying, but also you need to make sure that there's not information overload and you shouldn't be providing too much information. But then there's no real guidance as to what that right balance looks like. And so I think that is really confusing for organisations who are struggling with that balance. How do you, on the one hand, be really transparent, bring the most important information to the fore? What is the most important information? Because that is also a constant assessment as to what people are expecting is happening with their data, and that those expectations shift over time. But on the other hand, how are you not providing too much information and putting it in plain English? So I think all of that is to say that we do have a number of different regulators now that are getting into the data space, and it's not just the ACCC either. I mean, we've seen ASIC commence proceedings for the first time in relation to cybersecurity failings. That sort of happened last year, and that's making its way through the courts as well. I expect it's only a matter of time until APRA starts taking enforcement action as well on these sorts of issues, which have traditionally really been within the purview of the OAIC, which again has historically been much more underweight in terms of resources and funding compared to the other regulators. So I think they're all trying to find their way a little bit. It means that organisations are not entirely sure where the next missive is going to come from, and there are certainly some differences between the different regimes and also between the powers of these different regulators. So I'm not sure that there necessarily is a natural place for it. I suspect that if the privacy reforms come through in the way that the ACCC envisages, maybe they might find that there's less of a need, but also maybe not. Maybe they're really enjoying this new sort of foray into this space.
Katharine, did you have any thoughts on this?
Yeah, I have a couple. As Valeska has pointed out, so the ACCC has been bringing some cases under the consumer law in respect of misleading conduct about some companies' privacy settings or policies, and those have included cases against Facebook and Google and Health Engine. And some would say the ACCC should back off. We've got a privacy regulator, the OAIC, and privacy issues should be left to them to avoid confusion and overlap. I don't think that makes sense yet for a couple of reasons. For starters, our Privacy Act doesn't address all these types of misleading conduct, especially when companies are making representations about privacy beyond their privacy policies. There's also a general consensus that our privacy regulator needs more funding, more resources before it can effectively enforce the legislation, and that our privacy regulation itself, the legislation, is in urgent need of reform. It's relatively impotent in the face of our valid privacy concerns in the digital era. In Australia, over the past couple of years, we've had several consumer surveys about privacy attitudes, and the clear results are that consumers want more choices, less sharing. They don't want their data collected for unnecessary purposes. And some would say in response, well, pull yourselves together, read the privacy policies, choose the companies that offer better privacy terms. This is the privacy paradox theory, that consumers are lazy and unreliable witnesses about their true preferences. I recently tested at least some of the premises underlying this theory with the policies of some key online marketplaces in Australia, Amazon, eBay, Kogan, and Catch. I spent a whole week on the combined 30,000 words of those privacy terms, breaking them down into comparison tables, having regard to consumer attitudes reflected by those surveys. If I can just draw an analogy here for a moment to explain. When I was younger, I had a flatmate who was a catwalk model, which was quite depressing partly because I'm almost 5'5" and not a photographic treat, but also because I was going off at the time to work as an article clerk at Allen's every day, while she was being paid to go to spin classes and swim and eat salad and be dressed by designers. And I couldn't help but think how different my life would be if I was paid to do those things for no apparent reason. But my point is, I'm like the catwalk model of privacy policies. I get paid sometimes a modest amount to read every word of these privacy terms, while the rest of you are unable to do that because you're busy with your non-privacy policy work. But the sad truth is that I spent a week reading those terms and trying to distill some meaning from them so I could make a comparison of the choices they offer and the extent to which they respectively collect and share data. In short, that only revealed that that exercise is a waste of time. You should have paid me to eat salad. None of the companies set a commendable standard for privacy, and the policies all looked very different, but what stood out was their similarity in substance when you waded through those thousands of words. In my view, from these experiences of attempting to make comparisons and draw out real information, and especially any kind of choices, we're nowhere close to consumers guarding their own interests in this area. So at this stage, privacy representations do still need to be scrutinised under both our consumer law and the Privacy Act, and even where appropriate, the competition law, including our merger laws.
I think just to quickly pick up on something, the other thing is that there are some really obvious limitations to the Privacy Act. So we've got the employee records exemption, which means that probably in many cases the largest sort of cohort of personal information that a lot of organisations hold are not caught at all by the Privacy Act. We've also got the small business exemption, and if you look at a lot of particularly scale-ups or startups which have, really high growth, are capable of dealing in high volumes of data, and there are exclusions to the small business exemption as well, but in large part that's not going to be caught by the privacy regime. And so all of those, and also we're only talking about personal information, not de-identified information. So in theory, once you de-identify personal information, it falls entirely outside of the regulatory net of the Privacy Act. Now, that's not to say that there might not still be value, and certainly consumers might still see there being value in that, and that they should have some degree of control over. So I certainly understand, or it seems to me as though there are limitations and gaps there, and the question is, what is the best way to address them? Do they fall more naturally within a regime which is already really dedicated to data specifically, that is in sort of serious need of reform and updating, or should it be sitting more as a consumer issue? And is this limited to a consumer issue as well? So I think it's a tricky issue, and certainly needs updating. And the other thing actually is a key focus of these issues is in relation to direct marketing or personalisation or targeted advertising. And then, that gets dealt with to a certain extent in the Privacy Act, but that's also limited in some ways by the Spam Act regime, which is really out of date. And so you've got, again, these multiple regimes kind of getting at the same thing, but not entirely. How do they work together? Now, of course, Spam Act is regulated by ACMA, which is a different regulator altogether. So it's another example of the tension that we're seeing here across multiple regulators, multiple regimes that are really trying to deal with the same sort of issue.
Excellent. So we started zooming out, and then we've sort of zoomed in, and we did competition and privacy. I want to sort of, I suppose, zoom out again, and I'm going to move now to questions that are coming in from the audience. So please do post your question if you haven't done so yet. This event was framed as sort of law versus big tech, but obviously a missing piece in that is ethics. And we do have a couple of questions on ethics, but where does ethics fit in all of this, particularly around things like artificial intelligence? And Valeska, you mentioned before the AI principles and so forth. Do you want to start us off on that?
Sure. I think it's becoming increasingly important, and to a large extent, that is probably where the ACCC is trying to pick up on some of these issues. It's kind of the either the creepiness test or what are the out of bounds that maybe the law doesn't quite address. And so, as I mentioned before, we are certainly seeing a lot more organisations developing their own internal ethical principles around things like AI and data, and often they're sort of intertwined. What's really interesting is that when we help organisations try and develop those, we'll usually come up with some high-level principles with some optionality, and some of them are a bit more extreme than others, and you get into a room with decision makers who come in thinking that they're all going to be very aligned as to what their tolerance levels are. And it's fascinating to hear the conversations that come up when you're when they're trying to define those ethical principles. And often the tolerance is very different if those principles are being framed as something that is aspirational and for internal use only, as opposed to something to be made public as the ethical principles that the organisation is going to abide by. So I think it's actually a really interesting and worthwhile exercise, because it does force the organisation to really get on the same page as to what it is prepared to do. And I also think it's something that does need to be revisited on a regular basis as well.
Awesome. Katharine or Shoshana, do either of you want to come in on the question of ethics?
Maybe just to say this, that obviously it's super complicated, and I mean, there are different views by different people of what is ethical and what's not. And, Google search, for example, is intended to give everyone access to as much information as possible. That's legal, obviously. But then there is the whole question of the ethical elements of it. So there will be access to information that some people may say that's offensive to see that. And I don't know, I don't have a great example, but maybe, I don't know, maybe a video of someone drunk may be offensive to some people and maybe seem to be unethical to have that available on the internet. There are a whole range of how long is a piece of string, at what point is it that unethical and at what point isn't it. So all I would say about this is that it is a very live issue, and I know this is different. I mean, that's about content, and I know that's different to the artificial intelligence elements, which also have their own same ethical questions, like to what extent do you want to interfere with the artificial intelligence? At some point, decisions have to be made on artificial intelligence. So, they're all elements to it, but I think this is a matter of time, I think, for us to understand it. But I mean, history tells us that ethics morphs into laws eventually. So I think when it comes to be commonly known or socially normally considered to be that unethical, it probably starts to become a law. And I think the grey area is, what do you do before it becomes a law? And yeah, I think that's going to be an age-old problem. I don't see a quick or simple solution to that.
Excellent. All right, this is for whoever wants to take it. Are we likely to see property rights in personal data during our lifetime? And what would the ramifications be? I mean, the question says on the business model of digital platforms, so really the ramifications more broadly. Is anyone interested in that one?
I think it would be a fairly concerning thing to treat personal data simply as a matter of property rights. And I know sometimes people raise this as a potential solution to our data privacy issues, in that, for example, there's been suggestions that people could just be put in a position where they could charge companies for the use of their personal information, and that would solve all these issues because we would be deciding on those transactions for ourselves. That is quite a shocking concept to many people, especially from the European Union, where in other jurisdictions where privacy is regarded as a fundamental right, and it's similar to talking about, you know, trading in your own organs, that there are some things that we just don't treat as the subject of economic transactions in that way, and that it's part of our dignity and autonomy as human beings. And more than that, that treating these as a matter of privacy, of property rights, which can be sold away, clearly disadvantages people who have fewer resources and more need for money, and privileges those who can afford to pay for more privacy protective services. So I think it's a really fraught way of addressing these issues.
Thank you. So there's a question now for Shoshana specifically, asking if you could give an example of the level of technical details you need to solve a legal problem at Google, and how you go about learning how the technology works in your role.
It's a good question. Maybe I'll give an example. For example, when, you know, phones started to have Face ID recognition to open a phone, looking at concepts of what legal ramifications are there to using Face ID. So maybe that's like one that I can pull out of the air now as an example. And yeah, look, I think there are things that I would say come across my desk that I wouldn't know where to start with. I would be like, I don't even know what area of law to look at, but that's an area of law I need to think about. But you know, I think the real answer, I mean, to be more constructive than that is, you know, I think, and, you know, Katharine has alluded to this, I think you need to be well aware of privacy laws. You need to be aware of, you know, issues. I mean, a lot of these innovative products look at things like, you know, face recognition technology, or if you think about maps, how maps works, someone is driving around the streets, understanding and how Street View works, and like taking, you know, video footage of those streets. So things like that are obviously a privacy focus. And then there is the whole artificial intelligence element. So you obviously have to be aware of those artificial intelligence laws or proposals. And then there's probably a whole lot of others that, you know, the competition law issues are obviously something we need to be well aware of in the current environment. So I think you definitely need a general understanding of things. My background is actually commercial litigation. And actually, I'm surprised by how many of the lead lawyers in Google have a litigation background. And that's probably because as a litigator, you do come across what goes wrong. For example, in commercial negotiations, you do see a lot of, you know, you do get exposed to a vast array of different areas of law and things that have gone wrong in those areas of law. So maybe it's not a complete surprise, but I do think as time goes on, privacy obviously is a big area. You know, there are such a thing as technology lawyers, especially in the US. I feel like it's something we haven't really developed a course on pure technology law in Australia, and maybe that is because it takes from all these other disciplines. But yeah, I think you have to basically start with understanding why something could be a legal risk, and then understanding what technical area that could go into.
Thank you. Okay, so we've had some discussion of competition law already, and Katharine's also introduced some of the sort of international proposals. So the question is here, you know, Australian law, you know, if you're just dealing with an Australian market, Australian law can deal with competition and unfair competition in an Australian market. But of course, many big tech companies are outside the Australian jurisdiction. To what extent, how does that play out? I mean, is there, you know, is there a sort of international law role here? Do companies come under the jurisdiction of different national legal regimes for competition law? Does anyone want to tackle that one?
Perhaps I can answer to some extent here. And we have seen in a number of cases that there will be mergers raised, including, for example, the Google Fitbit proposed acquisition and numerous other mergers that have to be considered across multiple jurisdictions. Now, in each of the jurisdictions where the companies have their operations, including in Australia, there will be jurisdiction for the ACCC to deal with that merger and potentially bring proceedings concerning the merger if they believe that it infringes our competition law. In reality, the competition agencies generally speak to each other and attempt to cooperate to some extent in understanding what their own respective investigations are revealing, and to have some consistency where that's possible, having regard to the laws in the different jurisdictions in the outcomes of those mergers. But we've seen some big examples where the EU has gone one way and the US has gone another way. So that doesn't always work out, but that is one of the goals, and the competition agencies between jurisdictions are frequently in contact with each other.
Okay, excellent. Thank you for answering that. So another question that came up, and this was directed to Shoshana, so I might let you go first, but really it's a question that the whole panel might be interested in responding to. But Shoshana, you spoke about the risks of regulating too early before the risks are well known. Are there also risks in regulating too late?
That's a good question. I probably don't change my answer in saying that I think it's good to wait and see, unless it's obviously dangerous. But I'm trying to think of an example where regulation is too late. I mean, I don't know. I mean, I'm sure Katharine will say in many areas. But I don't know. I think of things like, you know, you look at something that occurred in a couple of years ago. That was the Christchurch massacre, and you look at that Australia very quickly introduced this abhorrent violent material law in reaction to that, and I think that was legislated in about in a very quick period. I think from the time of introduction of the bill to it being passed, it was a few days, and it was a very quick law and it was a very quick reaction. And I think that is a good case to show in some ways that, you know, there was this belief that, and for those of you who don't know, that was really to try and curb this sort of violent, that was a live streaming of a violent terrorist act, and the whole point of the law is obviously to make sure that those things aren't live streamed. And, you know, maybe that is a good example of showing that. But to be honest with you, I could tell you right now that would have happened with or without that law. I feel very confident there was no desire by anyone to have that, you know, visible or available. So I feel like that would have happened. And that's why I have trouble answering that question, because I do think these things self-regulate. I mean, the reality is digital platforms don't want to have a bad reputation. They don't want to lack integrity. They don't want to have bad content that makes them look bad. You know, there is a reputation element to what we do. And that does mean towing the line, and that's probably why I do talk about ethics in the way that I do, towing the line on the law and towing the ethical elements as well. And there's always going to be a grey area. For every person that says that should be different or that content should be removed, there's many people that say you should not be removing that. You know, people should be available, should see that. So I think you have to see both sides of the coin, that this is not very often one-sided. And to the extent it ever is one-sided, you can be very sure the digital platforms will react to the one-sided nature of it.
I mean, I think that where there is a risk in regulating too late is where we're talking about outdated legislation that is having inadvertent consequences with the way that technology or business models are operating today. So the original legislation didn't actually contemplate that. It's applying to it in a way and having an impact in a way which was never intended, and that causes all sorts of issues and risks and complexity and confusion. And then it's important to update it, and I think sometimes that does take too long.
I'd just say quickly that in two particular areas, you can definitely regulate too late. There's more than two. But just to mention mergers, for example, if you get too far down the line and realise what the impact was of, say, a digital platform swallowing up a nascent competitor, it's very hard to unscramble that egg. And likewise, when it comes to data privacy regulation, that if you say, let's leave it until the industry has developed, and that's a luxury we can come to later, well, the horse is bolted in terms of people's personal information being exposed to numerous parties for their commercial purposes if you keep on pushing privacy reform down the line.
Thank you. So we're going to have to wind up the main panel here. I'd like to thank all three of you for the excellent conversation. If we go back to our topic, law versus big tech, I'm feeling slightly more confident that law has a number of tools in its arsenal, and that big tech, in fact, is also looking to ethics and its own reputation in ensuring it doesn't stray outside sort of the bounds of social acceptability. So I think it's not, you know, we have some fighters in the field. It's not a lost battle. I think the big question is going to be, and the big question certainly among the panel were less about, can law, respond to certain issues, and more a question of how or which laws and which regulators and when. So still lots of questions, but we'll have to do that in another legal hour, I think. So I'll hand back to Andrew.
Thanks so much, Lyria. And on behalf of the UNSW Faculty of Law and Justice, I also want to thank our three panellists tonight, Shoshana, Valeska and Katharine. Thanks for taking time out of your busy schedules to be with us tonight. It's been really fascinating to listen to this discussion, and we want to thank you for your expertise and sharing your insights with us in this ever-growing area of interest and importance. The faculty's own work in this field now forms a significant site of activity, gathering expertise across our three schools. The support of our friends at Allens for the Technology, Law and Innovation Hub under Lyria's leadership has facilitated really exciting collaborations across public and private law, domestic and international, and also our legal theorists and ethicists. And also work, I should add, with our other university colleagues. Our combined degree of Bachelor of Data Science and Decisions and Bachelor of Laws, as well as standalone elective courses, including some which are co-taught with the School of Computing Science, evidence the faculty's commitment to meeting the professional and community needs going forward in this area. Thank you to all of you for tuning in live for this discussion. We hope you've enjoyed the event and leave with new knowledge and fresh ideas. It's been a real pleasure to engage with our valued alumni community through this year's Legal Hour, although sadly not in person. As I said at the start, this is our 50th anniversary, and I encourage you to have a look, please, at the faculty's website, where you can see a spotlight on alumni who tell us where law and justice has taken them. You'll also find information about 3 student scholarships that we have as our priority fundraising activity for our golden anniversary, consistent with our commitment to social justice and broadening access to legal education and diversity in the profession. Lastly, I hope to also see many of you online for our Hal Wooten lecture, our annual flagship lecture event, which will be held on October the 12th with our guest speaker, human rights barrister Jennifer Robinson. Good night and thank you all once again.